Hello, wonderful people. I trust that you're feeling very, very well and you are keeping safe. So you are welcome to Tutorials with Francis. I'm super, super, super excited to have this session with you. So today we'll be dealing with a very interesting topic, I would say, because I normally don't get folks asking me questions about it. So normally you hear questions like, so the relative passed on and I went to the bank and the bank are requesting for letters of administration. What is letters of administration? So today what I really want to do is to throw some light on letters of administration. I will do very well to avoid the legalese and all that. I'll just break it down for you to have a very fair idea on what letters of administration is, if in the event that you may want better or deeper knowledge on it, why not? You can send us an email and then we'll see how best we can assist. But for the purpose of this video, we just want to throw more light on what letters of administration is, so that in the event that a relative passes on, you have a fair idea of what to do, the information to make available, and then who can be of an assistance to you. So in fact, actually, I had a call from a very good friend saying that the relative passed on. They went to the bank and the bank was requesting for the letters of administration, and most of it I not hear them asking a lawyer, can you draft that letter for me? Spoiler alert, letters of administration is not a letter properly so-called, even though it goes letters of administration. So in this very short video, we will try and provide some clarity on it and how it normally works. And we'll try to keep it short and straight and then simple. So this is actually my first time of using Zoom whiteboard. So pardon me if it's not something I'm used to. I'm just exploring. So let's learn together. Now, normally at the demise or in the event that a relative passes on, this is depending on whether the person died testate. Let me try and capture whether the person died testate or intestate. So we say a person died testate if the person died with a will. So the person died with a will. And we say the person died intestate if the person died, I'm sure you can add, without a will. Now, if a person dies leaving behind a will, normally you would go to court for what we call probate. So even before I get it, the position of the law is that you cannot touch the properties of the deceased without the authority of the court. You would understand that these properties may be the personal properties of the deceased. So the position there until the court allows you to touch these properties. If you touch them, you would have been said to have intermeddled. So intermeddling, yeah. So intermeddling essentially is when you touch the properties of a deceased without the authority from the court. So you can imagine, how many of our, folks have actually, intermeddled with, properties of disease, and be informed that intermeddling, the position that if you intermeddle, you take the seat as an administrator. So in the event that, you cause losses to the estate, so let's say there's a vehicle, you sell it, you can be asked to, refund, or you can be asked to, bring the monies that you took for selling either the car or the vehicle or whatever. You are supposed to assume the position of an administrator. And if you're an administrator and then you cannot account for the properties which you are administering, that is a problem for you. So you can understand that most of our family heads that normally rush to, houses of disease, locking it up, taking over, driving away vehicles and then trying to sack the poor widow out of, the house are all breaching the law. But, the unfortunate bit is that most of us don't, because that is a clear case of intermarriage. And even under our laws, you cannot sack the widow and children from the matrimonial home. At least, if the position is even that if the house was, say, a family house, I mean, you should at least allow them 6 months to live there. You just can't immediately at the demands of the husband, then you go, chasing them out. You cannot do that. And even the position again of the law is that the house where the husband and the wife and the children were living in is deemed as a matrimonial home. And that matrimonial home is supposed to go to the wife or the surviving spouse. So it's not mind-boggling when you see family heads trying to vacate wives and husbands from a property that they have acquired with the other party. If they were living in that particular home, if it was a property that they acquired, whether it was acquired by the man, but that is a property that they were living in before normally the man who dies, well, the case may not always be the same, but whoever dies, if that is the property they were living in, the position in that house is deemed as a matrimonial home, and it would not fall part in the sharing of the properties of the person. Now, this is applicable in respect of letters of administration. That is where the person dies without a will. But where the person dies with a will, the position is a bit different. Today, our attention is on letters of administration. I'm just trying to provide a little bit of information out there. So if you are a family head, you have no right to go and sack, the wife from the matrimonial home. You really do not have any rights to do that. And also understand that the PNDC law, one that is the Interstate Succession Act, the Interstate Succession Act, even provides Succession Act, provides the priority of persons that can go to court to be made administrators. Administrators are essentially the person that can go to court to be allowed to touch the property of the deceased. Forgive me if I seem to be adding a lot of information together, but essentially, until the court allows you the right to touch the property of a deceased, you have no right to do that. That point should be made very clear. And if you go ahead and you touch the property without the authority of the court, you have intermeddled, and intermeddling comes with its own consequences. We'll find time and then just deal, strictly on intermeddling. But for today, we're just trying to provide some introduction on this. So where the person dies without a will, the document you need to touch the properties of the deceased is what we call letters of administration. Letters of administration. And I mentioned that if the person died with a will, you go for a probate. Keep in mind. So if your dad died with a will, the authority you need from the court will be a probate certificate, not a letter of administration certificate. It will be a probate. So if it's a will, it's a probate. If the person died intestate or died without a will, it is letters of administration. In fact, there is also letters of administration with will annexed. That is something that we'll talk about later. That is letters of administration with will annexed. It's something that we'll talk about later. But for now, our focus is on just letters of administration. So let's say your father is no more, your mother is no more, and you have gone to the bank and the bank is asking you to bring letters of administration. I have explained that the letters of administration is a document that the court would give to you. And how does the process start? The process would normally start with an application, for the grant of So normally grant of the notice of letters of administration, and I would explain this. So normally this is what happens. Your lawyer would file this application for you. Then the application, so then it's not a letter, it's an application. So your lawyer will do that for you. It will be filed in the court. Let me use the right term. It will be filed in the court. Now a date will be given. On that day, your lawyer will be in court, and then your lawyer will move the application. Moving the application essentially is that your lawyer will speak to the document before the court. And if the court is satisfied with what the lawyer is saying, they will grant you'll be given the notice. So the notice essentially is that we would have to go and post or paste a notice at the last known address of your father or your mother. We should understand that all that you are requesting for is that you should be given the opportunity to touch the properties of your mother or your father. But because you are the one in court, and the court does not know other third parties who may have an interest in your father's property, it is necessary for the court to give you the notice, not the actual document. So you'll be given the notice to go and post at the last known address of your father or your mother to tell the world that Francis wants to be given the power to touch the properties of the deceased. If you have any interest, come to court. Normally, if you have an interest in the properties of a deceased and an application for letters of administration has been filed in court, you can file what we call a caveat. So normally the notice will be posted at the last known address for 21 days. The notice will be posted for 21 days. Guys, keep in mind, it must be posted for 21 days. It must not be less than 21 days. Unless, of course, there are exceptional reasons why you think the notice should be posted for, say, 7 days or 14 days, but demanding that the court would hardly grant such a request, because we need to make sure that all interested parties are in the know that you, so and so, wants to be given the power to touch the properties of your father or your mother. So it must be posted for 21 days. After the lapse, and who does the posting? The posting will be done by a bailiff, that is an officer of the court. So an officer of the court would come and post the document or the notice for the grant of letters of administration on the last known address of your father or your mother. Understand that it need not be the property of your father or mother. We just want to know, where was he or she living at the time of his demise? It could be that at the time of demise, he or she was living with you. So that would be his or her last known address. And it must be pasted for 21 days by a bailiff of the court. The bailiff is an officer of the court. Good. So after the 21 days notice, then the bailiff would normally do what we call affidavit of service, showing that he has indeed posted it at the last known address for 21 days. After the 21 days, then you will go back to the court. No, not even the court, but the court clerks, and then they would give you the letters of administration certificate. So that is the certificate that you will go and give it to the bank, or you go and give it to whoever is requesting for it. And understand that any institution you will be dealing with in respect of a deceased person will be requiring letters of administration. Because without letters of administration, we would not know whether you are a rogue or you are just, a smart person trying to benefit from the properties of a deceased. So they wouldn't mind whether you are the daughter, whether you are the son, you are the wife, you are the husband. Once you don't have letters of administration, they may not allow you to have access to whatever the person had. Assuming if it's the bank, you can't even check the account balance without letters of administration. So it is very, very, very important. So Then again, without letters of administration, you cannot touch the estate or the properties of a deceased. Now, when I say properties, I don't only mean land. It could be the shoes, it could be the bag, it could be the earrings, it could be the earpiece, the phone. All that forms part of the estate of the deceased. If you don't have letters of administration, you cannot touch it. If you do that, you have intermeddled, and intermeddling has its own consequences that you just don't want to find yourself in. But the only problem is that most of us are not much educated on this stuff, so there seems to be a lot of abuse out there. There seems to be a lot of abuse out there. So now that you know this, please be on the watch. If you know a family or whoever it is trying to bully his or her area around, trying to search you guys from the family properties, understand that the law protects you, especially if you are the spouse and the child. The law protects you. So just you can get in touch with any lawyer, and then they will provide further clarity on this part. For today's session, we just want you to understand what this whole part is about, letters of administration. Good. Now, what should be in a letters of administration? So essentially, it would be, so whoever is applying, you are the administrator. So the law allows for 1, 2, 3, 4. It just can't be more. But mostly you see 2. Hardly in my practice, I'm yet to see. Okay, I've seen 3, but yes. So I've seen 2, I've seen 3, I've seen 1. So mostly you are ranging around 1, 2, 3. But it should not be more. 1, 2, 3. If it's a son, if it's the wife, and then a family member, it's fine. I mean, in a family member where there's cordiality, the wife and then the son or daughter, or the husband and daughter, son can go. But in a family where there's a lot of chaos, you would want, family member to also be part, because I understand that under interstate succession, that is PNDC law 111, the family has a share. PNDC law, sorry, PNDC law 111. The family has a share. So mostly, since the family has a share, it's only fair that they are also made administrators, but it's really not by force. Honestly, if you can provide a justification why the family member need not join. Mostly, it could be that there's a lot of acrimony going on. The family member don't even want to join you to go for the letters of administration, or they are just doing their own stuff. Why not? You can just go to court and then provide a justification why the family members need not. It is not by force that a family member should join you. But normally the court would want to find out why there's no family member. Is it that there's a problem? What if, after you being given authority to touch the properties, you ignore the interest of the family under the law? So that is why you have family members join. But it is not the case that by force there has to be a family member. But please understand that it's just because normally, so the situation would determine whether the issue of family member joining would come up, because there are times that it would only be the child and the mother may be there. So it all depends on the reasons and the justification that you give to the court. So normally, what information should you provide with your lawyer in the event that you may need letters of administration? So essentially, it will be your name. The person who wants the letters of administration will be your name. It would be your address, that is house address. It would be either I am the wife, or I am the son, or I am the daughter of the deceased, and you need to provide the last known address of the deceased. You need to provide a death certificate if there's one. Even in some instances, you see a mortuary certificate, but a letter from the hospital showing that the person was brought into this hospital. There are even peculiar situations where a burial certificate may be necessary. You just need to provide an evidence to show that indeed the person is normal. Understand that there are rogue persons out there that may want to outweigh the court. So the court needs an evidence to show that indeed the person is normal. So either a death certificate or a mortuary certificate or burial certificate, whatever certificate, just anything showing that your father or your mother is no more. Then you need to list the properties, list the properties of the deceased. Then again, when I say property, I'm talking about movable and immovable properties. Movable and immovable. So movable properties will be see my earpiece, my laptop, my bag, shoes, whatever. Then immovable properties will be landed properties. So let's say there's a land, there's a house, yes, those are immovable properties. And you need to also provide the values. So the movable properties will be normally it's categorized under personal effects. Okay, not always. So let me clarify. So let's say if you have shoes, chains, watches, those will be personal effects. But if you have maybe you have a vehicle, you have a van, a clothes, whatever, that would be an a movable property. But the personal effects are those that you use on the person, like my singlet, my suit, my shirt, earpiece. Yeah, I'm sure you get it. Then the immovable properties are the landed properties. And you need to provide values to them, fair values to them. Don't undervalue them. I mean, it is not good to undervalue them because, I mean, if your father left you with a property in airport, which probably should be costing, say, $300,000, and you go to court and you are costing it around 100,000 Ghana cedis, clearly you are undervaluing the property. So you need to provide fair values. And the caution I would give you guys is that if you undervalue the property, the court in certain cases may want to appoint a surveyor to go and survey the land and then, or a valuer to go and value the property and then put an amount on it. So it is not in your interest to devalue it. We are not also saying that overhype it. That's not necessary. We are saying that put a fair value on the property because you would be paying an estate duty on the value. And normally the estate duty is 3%. So you pay an estate duty of 3% on the entire value of the property. So if we add the personal effect, if we add the number of vehicles, if we add the landed properties, and it's like say 100,000, or let's say it's like say 500,000, 500,000, so 500,000, 500,000 Ghana cedi, you pay 3% of 500,000. But understand that there are also administrative charges. The administrative charges like the filing fees and then certain charges you may pay at the registry. So essentially, this is what letters of administration is. This is what letters of administration. It is the document that you need to touch the estate of your loved one. And trust me, under the laws, without it, you cannot touch it. It's an offense to touch the property of a deceased without letters of administration. Hey, but how many know this? Not many know this, but hopefully you do. And if you touch properties without a letters of administration, especially if the person died intestate or died without a will, I'm saying that it is what? Intermeddling. It is intermeddling. And you don't want to be found guilty for intermeddling. We just don't want that. So what else? I think I have touched on essentially everything. So then again, letters of administration is not a letter. It's not a letter that your lawyer can write for you. So if you have a lawyer who says, come and let me write a letter for letters of administration, sorry, that will not work. Forgive me for the background. I'm still at the office. Good. So and I think that is it, at least for introduction purposes. So guys, if there's a question, you can just put it down there in the comments and then I would answer. If you want further clarity on something, just let me know. We'll try and then do another session on tested, that is with will, where the person dies, leaving a will on probate, whether the process is not really different. Except that it's really the same. And understand that, let me also talk about the charges. Understand that depending on the value of the property, now some lawyers may charge based on the value of the property. Some may also go by the Ghana, bar scale of fees. You can always negotiate with your lawyer. Most lawyers are very reasonable, so you can always negotiate. But today, that is not what we're talking about. We just want you to have a fair idea of what letters of administration and then the steps to take. So please, at the demise of a relative, don't wait, for years. At least immediately after the burial of the person. It may not even be after the burial, really. But immediately after the burial, just tell the family to take steps and then procure the letters of administration before you touch the estate. And if you are the spouse, it is in your interest. If you are a child, it is in your interest. Push for the family to get the letters of administration because it would benefit you. If you have family members coming to take over properties, don't sit down. The law provides you with rights under PNDC law 111. So don't sit down and then watch family members come suck you out of the only property you made with your husband or with your wife. It doesn't work that way. Stand up, get a lawyer, file for letters of administration, and then get it, and then go and then administer the estate. Because once you are made the administrator, you now have power over the properties, and you will distribute it according to the categorizations in the Interstate Succession Act. Of course, in actual practice, mostly what works is that once the order has been given or once you have been appointed as an administrator, mostly you would have to sit with the family members down and then you determine how to share the property. Because if it is a house, how are you going to share it into fractions? Because the PNDC law does it in fractions. So if it's a house, it will be difficult to share it in fractions, unless of course the families come together and then they agree on how this division would be done. But if you're a husband, if you're a wife, if you're a child, it is in your interest. So please take it serious. Don't sit down to be bullied by family members who never contributed to the success of your mother or your father. So guys, I hope this short session was beneficial. Once again, if this is your first time visiting us on our page, kindly like it, kindly share, kindly subscribe. Just do whatever you want to do. Yeah, and you can also send us a comment. We'll do what to respond. If there's a topic you want us to discuss, why not? Feel free. We'll do that. So thank you very much. Have a blessed day and God bless you. Thank you.